So much for still being with us on Morning at NTV. We get to look into our Kickstarter looking at the NRM Parliamentary Caucus that had a sitting and some of the resolutions that came out of their party sitting in regards to the UPDF Act. As we do that, you're reminded that we're streaming live on our X platform, NTV Uganda, as well as our website, www.ntv.co.ug. I am Priscilla Regina Nalwoga. Now, in response to a recent Supreme Court ruling that declared the trial of civilians in military courts unconstitutional, the Ugandan government is proposing amendments to the Uganda People's Defence Forces Act. These amendments aim to address the legal and constitutional issues raised by the ruling, as well as redefine the jurisdiction of military courts in Uganda. In response to that, members of parliament of the ruling party NRM did resolve to support proposals that would see civilians accused of illegally possessing specific firearms tried in military courts first. Now, just look at some of the resolutions. We, members of the NRM Parliamentary Caucus Assembly today, which was the 21st of February 2025 at State House in Entebbe, do deliberate on matters of national importance and do hereby resolve as follows. 1. To support the proposed amendments of the UPDF Act as presented by the Attorney General with the following broad principles. Principle number 1 being that misconduct by serving military personnel be tried in the first instance by the military courts in court-martials with the right of appeal through the civilian court. Principle number 2 that they all agreed upon was that civilians who acquire specified or unspecified firearms illegally be tried by the military court-martial in the first instance with the right of appeal through the civilian court. And then the third resolution also did indicate that provision be made to provide for rights of appeal from decisions of court-martials to civilian courts. So those are some of the resolutions that came out of the NRM party sitting. We are privileged to be having the spokesperson of the Parliamentary Caucus of NRM, and that is Honorable Brandon Chintu. Good morning.
Good morning.
How are you?
I'm brightly fine this morning. But you have challenged me. You've specifically done the job that I was supposed to.
No, now you will elaborate as to how you came to these decisions. We are equally joined by Counsel Wanda Samuel, who is also an observer of these ongoing proceedings and the aftermath of the Supreme Court ruling and how different actors and stakeholders are actually responding. Good morning to you, Counsel.
Good morning, sir.
How are you?
I'm good, how are you?
Very good. Let's start off with the spokesperson to be able to speak further into some of these resolutions that came out of the sitting. Mr. Chintu.
First of all, the NRM Parliamentary Caucus has a routine schedule for meeting that we agreed every first Friday of the month we do meet. And these meetings can be conducted whether with the national chairperson or with us, the executive. Our constitution mandates us as the executive to call for as long as we have something very urgent, very important. We're in charge of producing government business on the floor of parliament. So we have to interact always. Now, our usual routine meeting came coincidentally 2 days, I think, after the Supreme Court ruling. We gave it a priority also to understand and appreciate. We had a conversation about it. And it gave us a great opportunity to know, to see and appreciate and probably have a second thought. So we asked the Attorney General. In between, I sit on the Committee of Defense and Internal Affairs in Parliament. We had this brought for an amendment before us, the bill. We had set up a committee to go for benchmark. But then after the ruling of the Supreme Court, we said now we cannot do a benchmark on something that is not there at the moment, from our understanding. So in consultation with the Attorney General and other members of Parliament, actually this 11th Parliament here is very privileged. It has so many great brains, the academias in law, in medicines, and all other fields. We chose to have an extraordinary caucus, which we held last Friday, specifically to address this issue. We had 2 issues on the agenda, but this was the first priority. We had requested or ordered or instructed the Attorney General to withdraw the bill so that we further understand what it meant. From the basic knowledge we did understand from the reading, interesting this morning before we came here, I was trying to interact with council here to tap some bit. I popped some questions and I'm waiting to hear them answered. Because now I'm also doing benchmarking to understand.
But you said you can no longer benchmark if the process is already done and dusted.
I can have.
So is this a personal benchmark?
Thank you. I can do a personal benchmark to enrich myself.
Okay.
So the Attorney General came with proposals, but the most important is that the Supreme Court ruling guided and made the ruling. And we are also very much aware about the constitutional, how it says which authorities does Parliament have and where it doesn't have to. Now, on one of the recommendations, and I think the most important leeway was the issue of appeal. That the court martial, counsel was telling me that was in court there and saw a soldier that did not even have hope. He was waiting to go to heaven. Probably if the general, whoever was in charge, would make the sentence. But now, also looking at other countries where the court martial operates, how is it instituted? And when you look at the Supreme Court ruling, we simply went. And then when you read, which is challenging, that the Supreme Court declares itself on civilian. And I was asking counsel, how does this work? And then I remember somewhere where Supreme Court talked about a division within. And I think the most beautiful thing is that the resolutions, these are all resolutions as the members of Parliament, that as we meet we can have a position. But does not mean this is what we bindly agreed, because Parliament doesn't sit in Entebbe. But this is a position, and this being a public law, there will be an opportunity that these councils can come and give. And when these laws are amended, we shall have a committee stage within Parliament. And we can go article, we can go clause by clause. And I think such amendments there and then in that committee sittings can be raised. But simply the caucus was there to implement and respect the Supreme Court ruling.
Okay, this deliberation was in light of various testimonies from affected persons and communities, also in consideration of some historical factors. Could you speak to us about some of those?
We got a history of the General Court Martial, especially in some regions, say Karamoja and then Teso, but there are also some other arguments around it. But it did really function well, where it relieved people from being masked left and right and center. Those people from Karamoja held so many guns, and there's that program of disarming, which was also a process. So it's instilled discipline. And also, initially when I was growing up, I did not appreciate Swahili, because Swahili was used to abuse and steal. So there's also some element of the soldier seeing a man and a woman in uniform. These are brutals, so it instilled discipline. But then some arguments will say, well, we also have some other serious cases. We have a division crime, the division crime court that can try that. So we need really to be helped so that this law, these amendments, if I stand and make an oath to protect and defend the Constitution, what does the Constitution say? And we would like to be brought up speed, because who knows, we could be candidates of the General Court Martial. Oh,
that's a debate that has also come through, the corridors of social media. Council Wanda, now you're going to take us to school, one resolution by another. Specific firearms possession, a proposed amendment suggesting that civilians found in illegal possession of specific firearms should be tried in initially military courts, with the provision to appeal through a civilian court. This proposal is seeking to balance national security concerns with the right of civilians to a fair trial.
Thank you so much. The question which will linger in there is, what are we looking at when we talk about specific military equipment? You realize that up until 31st of January, people found in possession of even a pistol were being charged in the General Court Martial. And yet, ordinarily, civilians can own pistols. And the issue which comes into is illegally found in possession. Now, at what point do we confirm that someone is in illegal possession?
Okay, even if it's their own firearm that is, processed legally.
Yes, see, don't matter have a firearm.
Yes.
Now the question is whether I have it illegally or illegally. Now the only way you can confirm that I have it is illegally is through a trial.
Okay.
Now, and we are saying that the General Court Martial or a military tribunal cannot have the knowledge, the skill to find out the illegality or give a fair hearing to someone. Now, the normal courts, to me, we have the Criminal Division of the High Court, we have the International Crimes Division of the High Court. These are courts we believe can still try people, even those who are found in possession of any arm that government deems illegal. I'll give an example is that we have treason suspects in this country. Just last week, doctor and the colleagues were charged. But in July last year, we had the 36 Kisumu who were tried with treason. And their matter is now currently at the International Crimes Division. We believe there is no bigger crime in this country that cannot be tried by the normal courts. And the plan, the intention of creating a specialized court, to me, I'll call a military court or general court martial, even if they made one under the divisions of the High Court as a specialized court. I'll equate it to how we have the industrial court. It's a division of the High Court, but not with exclusive power to try all offenses. To only try offenses related to labor laws. Now, if we were to try to create a division of the High Court to deal with military issues, then to me I would still insist that that division should be dealing with military-related issues, and this may include discipline of military officers, but not necessarily all offenses, which may involve one having firearms and the use of the same firearms. Because what offenses may come under the use of a firearm can be murder, it can be robbery. These are offenses which can be tried in the civilian courts, either the Criminal Division of the High Court or the International Crimes Division.
And yet at the same time, we can't say that a military personnel is having illegal possession of a firearm.
Yes, a military personnel may be in illegal possession of a firearm, which they're not supposed to have, because once you're in the military, you are assigned your firearm. So if you found with, if you go to the armored brigade and pick out a grenade that you're not supposed to be with, as a soldier who is stationed in Machindi, then you're in legal possession of that firearm.
All right, Mr. Chintu, with consultation to the Attorney General, specific firearm possession, is that to say that in the amendments they would have a registry of the specific firearms that are, present in Uganda or even worldwide?
Actually, we popped that question, and I think in the detailed amendment, there will be specific firearms. I am not an expert in security, and for me, the best protector is my God, so I'm not even interested to acquire any firearm. But we are yet to know, because they also, Council here is telling about Gulnet, there are so many, there are even some other things that people may assume that these are firearms. So we popped that question, and in the consultation of these amendments, we shall also have security experts to tell us, to define what is a firearm. So
this is also to say that in case a firearm does not fall on that list, then that matter goes directly to civilian court. Actually, is that the translation?
Somebody also, Council here was talking about specialty, and then some colleagues were arguing, now if these people are sent to civilian court, and maybe this person has a gun, there are different types of guns, the generals, who are also lawyers, may be in position to understand which might not be in the capacity of the civilian judge. And then some lawyers argued and said, we the advocates, we are trained to examine and understand everything.
Yes.
So it's quite a nice argument, but to me, where I see from the submission of counsel, that this is going to help us to have the best. And probably, I don't think you'd be an aspirant to go to the court.
Okay, Counsel. So in light of this list, when it does come out, and so there are those firearms that are not on that list, what is the legal translation of that in terms of which court that gets to handle their issue?
The legal translation, one would be if indeed they go ahead and create a division of the High Court. But as my brother Brandon was trying to talk about, where a judge may not be in position to properly articulate, that may not be true, because I'll give an example. Like under the Uganda Wildlife Act, we have specialized prosecutors who come and prosecute matters related to wildlife, but in the normal courts. So we don't have a special court for wildlife, but these are prosecutors who have trained in that, and the judiciary has gone ahead to even train particular judicial officers who are now stated at the Wildlife Antiquities Court in Machindi. So the purpose of that is that someone who is legally knowledgeable, what else they need is a special training or skill to be in position to handle a particular matter. So on the issue of the skill and speciality in the firearms, in military hardware, we believe can be handled by the ordinary judge. By the time someone becomes a judge of the High Court, they have practiced for a minimum of 10 years. So in a minimum of 10 years, if you must have interacted with some of these things, and you must have really gained specialization in that area if you intend to really practice in that area. You realize that even as advocates, not everyone practices in the general court martial. Previously, when it was there, a matter would come to a lawyer and say, no, I don't go that side. So we still believe the civilian courts can still handle all the matters, even involving firearms, if anyone is following the firearm.
Okay, interrogating appeals process. The amendment intends to establish a clear pathway allowing individuals convicted by military courts to appeal decisions in civilian judicial systems. And this is aimed at actually enhancing the fairness and transparency of military judicial proceedings. What's the translation of that? Let me start with the spokesperson. What was the mind behind? Where's the fairness and transparency, which you can already get in the civilian court?
I think fairness would be that the legal man tries to explain to that.
Okay. Council Wanda.
Thank you. So the issue of appeals and fairness stems from a recent Supreme Court decision we had before the Kawaziguruka case. There was a case, I forget the name, but he was a captain. So he was convicted in the General Court Martial, appealed to the Appeals Court Martial, then appealed to the Court of Appeal. And then the Court of Appeal ordered for a retrial in the High Court. So in the High Court, he was convicted. He appealed to the Court of Appeal again, and then he appealed to the Supreme Court. Now, the Supreme Court said that you do not have a right of appeal from the General Court Martial to the civilian courts. Because a right of appeal ordinarily is a creature of statute. It's a creature of law. So if a particular law does not provide an appeal to a particular court, then you cannot appeal there, even if you're so much aggrieved. So the UPDF Act only provided for appeals up to the Appeal Court Martial, Court of Appeal. Now, we had scenarios where some offenses carried a maximum penalty of death. And our Constitution says that the death penalty can only be implemented after the highest court of appeal, which is the Supreme Court, has confirmed that death penalty. Now, there was a lacuna. And even in the earlier amendment, which had been presented before the Kamazuka's decision, they were trying to cure that lacuna of you can appeal from the General Court Martial to the Appeals Court Martial Appeal Court, and then to the Court of Appeal and then the Supreme Court eventually. And that was in line with what the Constitution of Uganda says, and Article 22, to ensure that if you're sentenced to death, then it should be the Supreme Court to confirm that position. Earlier, there was no that provision, and therefore that left a legal lacuna in how to deal with those matters. So to me, when they say for fairness and transparency, as we've said prior, you cannot get fairness in the military court as per it is established today. if they create a military court, which is a division of the High Court, and it's manned by civilians who are judges, who are qualified to be judges, who have experience as legal practitioners or as judicial officers and have risen through the ranks, then there is...
So in order to remedy that you'd have all chairpersons of the military courts possessing legal qualifications equivalent to High Court judges. Would that be a remedy to what you're saying? And would it be applicable still? It
would not be a remedy applicable here, because we are saying if we are to have anything resembling to a military court, then even their judicial officers should go through the normal procedure of appointing judicial officers. They should go through the Judicial Service Commission. They should apply for their jobs. Go through the Judicial Service Commission. Then they are recommended to the president, because the Constitution says he has the appointing authority for judges of the High Court. Now, once you are appointed as a judge of the High Court, now it becomes the duty of the principal judge to allocate a judge to a particular division of the High Court. What that takes away is the prerogative of the president that he has, that if I appoint you, then you're under my command fully. Now, if we are to have, even if we are to create a specialized court, and then we do not put in a situation that officers in that court go through the normal Judicial Service Commission recruitment, and they are only appointed by virtue, one, I'm a military officer. The Supreme Court said, and we all were aware of it, is that military officers take an oath to defend and protect the commander-in-chief first. Now, if that's the oath you take, then you have an obligation to listen and adhere to the commands of the commander-in-chief. Now, under the Judicial Service Commission, and judges or magistrates appointed under there, they take oath to defend and protect the Constitution. Now, we believe whatever they will be doing will be in line to protect our Constitution. So, until everything is streamlined to ensure that the process of appointment, the security of tenure for the judges in that court is guaranteed, then we cannot have any semblance of fairness or fair trial in those courts.
Okay, all right. So in response to that, we also do have the Special Forces Command, which is known as the SFC, and the Reserve Force. And the proposals do make change, including formal recognition of the two as distinct branches of the UPDF. This formalization reflecting the current operational realities and structures within the Ugandan military. And what would be the implications of that as far as justice is concerned?
See, the distinction of the two may not necessarily be there. It may be there in the statute, a book, because they have put the distinction. But we all know when it comes to forces, any security forces, let it be UPDF, let it be prisons, let it be police, there is the command, and the command is the highest. So if you are in police, the IGP is your commander. And whether you're in this unit or in that unit, they will still make that command. At times, even the commander-in-chief, because for security reasons, they may issue a command to the IGP on what they should do. So the distinction may only be there in the statute books. That's my understanding of that. Yes, I do not think we shall have any better distinction. All
right, so in terms of distinction, as Council has rightly put it, Mr. Chintu, let's talk about separation of powers. If he has rightly put it, that if you're having a person who is the chairperson of the Marshal Court and their core responsibility is to take on the orders of the chief in command vis-a-vis what should be the normal court procedures, then that means that there's a conflict of authority, a conflict of power between the judiciary as well as the army. Have you guys had that conversation as the Caucus parliamentary meeting?
We did not have a conversation in that line, but it's something to reflect. But how does the court martial come in place? I think it's an act of parliament. So parliament does its work, and like Council says, I think that's Article 95, where we're not supposed to tamper with...
Article 92.
92, where we're not supposed to tamper with such a ruling. So I think we just need to understand who does what, where, and when. But the challenge we have is that sometimes we get to understand very little between politics and now policies or constitutions. We mix, because everything we put into politics, however proper, however it will be lacunaless, if that word exists in law, there will still be some bit of politics. A counsel here has just told you. Now, I was still popping the question, and I would love that he gets to give us here and the rest. The Supreme Court says civilians should not be tried in court. But now the Commander-in-Chief, and who is also my chair, gives you the history as to why it's very necessary, and quotes the level of national security, which is really right, that as we go into the 2026 elections, we need to have a stable country. Actually, for anything to bound happen in this country, we must have stability. Now, this is a political safety statement and measures, but in the meantime, we have a court ruling, which is constitutional now. And on top of this, still the appointing authority is the in charge. So it will be very difficult. You may have it in paper, but when you go in reality to make institutions function, it could be different and difficult for you to put those separations.
Okay, all right. So, Councillor Wanda, is this to say that these resolutions are in line or not in line with the Supreme Court ruling that was? And are they aligning in terms of recommendations?
Partially, yes, they are aligning. We all know the sentiments of His Excellency, the President of this country, when it comes to the General Court Martial. I don't think he believes the country can run proper, or justice can be dispensed without us having military courts. But our understanding is that justice can be dispensed. One, when the court says civilians should not be tried in the military courts. And we have about 5 decisions of the Constitutional Court, and only one was appealed against. They were all to that level. What the earlier courts, the Constitutional Court, had ignored was the issue of soldiers. Now the Supreme Court says that even soldiers should not be tried in the military courts for any offenses that can be tried in the civilian courts. What does that mean? That you can try them for other things, disciplinary related, but for as long as there is an offense that requires a jail sentence, bring them to the normal courts. Now, once the normal courts, and the purpose of the normal courts is that the standard of proof decided is very high. It's beyond reasonable doubt. And even the procedure followed in finding you guilty or innocent is thorough. I was having the chat with him of someone who was being tried in court, and the gun had mask tape. And that's where they had put the number of the gun. And that was a gun which was being submitted in as an exhibit. In all fairness, that person could never get a fair trial from that court. So the Supreme Court has said that even military officers shouldn't be tried in the military court for any offense that requires a sentence. However, if they have committed an offense and they have been convicted by the normal courts, and we believe that such offense brings disrepute to the armed forces, then you can go ahead with your disciplinary issues, or probably dismiss with disgrace, probably demotion in rank, such things. So the recommendations are entirely trying to bring back the general court martial in another form, to still try civilians or military officers with particular offenses, but only that we tend to forget in most cases. In 2005, Honorable Mwanga Chivumbi went to court to challenge, I think it was Article 32 of the Police Act, which requires people to seek for permission from police to hold rallies and peaceful demonstrations. The Constitutional Court struck down that particular provision. Parliament came back in another form with the Public Order Management Act, and in there were, I think, Section 8. When it was enacted, still people went to court, they challenged that particular provision, and the Constitutional Court declared it unconstitutional. So we don't think there will be any difference here. If they bring back under the UPDF Act amendments, bring back such a court, I'm very sure we shall go back to court and challenge it.
All right, we'll continue to be observing, different stakeholders and how they will be responding or contributing to these proposed amendments. We do have Stephen Bide, who is on ground at the High Court at Twin Towers for the case of Aaron Kiza that will be handled yet again today. Good morning to you, Stephen.
Yes, good morning to you. We are coming to you from Twin Towers here in Nakasero. We are the Civil Division of the High Court. Today, we expect a ruling from the judge, Douglas Singiza, or anyone from the High Court regarding the habeas corpus application that was done from the lawyers of Dr. Kiza Besigye, but also we know that Aaron Kiza is one of the lawyers of Dr. Kiza Besigye. He was sent to Chitara prison for a maximum of 9 months. That is after the military court found him in contempt of court. These are lawyers, part of the lawyers of Aaron Kiza and Kiza Besigye. I have here George Musi, I also have Katoto Musime and Tobias and others. But let me engage one of them, at least on the issues concerning this ruling, but also the one of the NRM members of Parliament who sat at a table with the President Museveni and said that, you know what, we need to amend the UPDF Act and maybe see again civilians in court martial. Let me begin with Katoto Musime here. First of all, we expect the ruling, right?
Yes, we expect the ruling today, but it is so fishy that the prisons are ready and willing. Actually, they communicated that they are bringing Aaron Kiza today in court for his ruling, but surprisingly, the judge is saying he did not issue any production warrant. The lawyers are not aware of what transpired. We actually got the information from Chitari and from Aaron himself that he will be brought to court today. But to our shock is that the judge is actually not sure whether Aaron is coming, and is also asking us the same question. So it's a fishy action that we don't believe he's being genuine to himself, and he's actually telling us the truth. And however much, whichever way it goes, we shall have the ruling the way it is. In fact, we are not interested on which side the decision will take on, because we have seen the decisions he has made. He's just a quarrelsome judge these days. I don't know whether it has now become a habit of judges to quarrel in their rulings and not tackle the issues of and substantiate the matters as raised by the lawyers, but they are interested in their own decision and maybe quarreling with the social media influencers and activists, which is their role. They have to express themselves and give it out. If you are not interested in being criticized by the activists, then do the right thing, follow the law, and also be on point.
You know, today makes it 50 days since he was sentenced. And of course, from the Supreme Court ruling, his continued incarceration, does it really make it his human rights being trampled upon?
Obviously, he's in an illegal detention, as we have always said, because he's being held in Chitaria without a remand warrant. The challenge that these people would face in their individual capacities is that they will be charged and taken on for the violation of individual rights under the Human Rights Enforcement Act, and each person shall pay from his own pockets, including the government being vicariously liable. But we always call upon people, if you have the power and if you hold the office, do what the office requires you to do, because the laws are clear on what you are supposed to do. Pronounce yourself that the detention is illegal and the person should be released unconditionally. That's what we all require from the judge, nothing else beyond that.
That is Counsel Katoto Musime from Mugisha and Kiza Kampala Advocates, where Aaron Kiza is also a partner and he works with him. But also, let me turn to a person who has stood before the General Court Martial defending the human rights of others, but also him being a lawyer, George Musi from I'm forgetting the law firm, Pest Advocates, yes. You being part of the lawyers who have sat before the General Court Martial, when we see the Supreme Court ruling saying that, you know what, trial of civilians in court martials should be stopped, and we see members of Parliament sitting with the Commander-in-Chief saying that, you know what, we need to amend the law, amend UPDF Act. What does this spell for civilians like Aaron Kiza?
Of course, it spells bad faith. The Supreme Court decision indeed gave some advice and proposals for amendment. However, it seems the main point for the NRM caucus is the issue of trial of civilians, which, if you look at this total of the decision and even the lower court decision, what the court was against that, was against what it asked them to amend, was targeting the independence of the court, the composition of the court, and their competence, such that people, even soldiers, can get some bit of a fair hearing. However, they seem to be treating those on the periphery, and they are streamlining the issue of civilian trials, which I think, if the law is passed in that nature, it risks being thrown out by the Constitutional Court again, because the Constitution bars legislating to defeat a court judgment.
And for Dr. Kizza Besigye, his ruling for habeas corpus, according to court, was overtaken by events. And for Aaron Kizza, you were here. I know you are not here by accident. With or without the ruling, what does it mean for the rights of Aaron Kizza, who was sent by the General Court Martial on a ruling that later on was defined by the Supreme Court ruling that, you know what, this isn't lawful? What does it mean for his own rights, but also on rights of others who are still on remand and others who are still detained by the court martial, like Machete and others?
Of course, the nullification of the trial meant that the Supreme Court only stopped short of nullifying the proceedings and declaring them a nullity. What that would mean is that we are now seeking subsequent orders for the case of Aaron to see that those people are released. And even the Machete has referred an application. So the question would be how responsive the courts are in ensuring that these matters, these cases, are quickly handled and disposed of. Mindful that there are people who are in custody, it's about people's lives, and the transfer of files and the subsequent charging is not within our control, and we don't know when that will happen. So it's important that courts prioritize the issue of rights over anything else.
And finally, for you, Councillor George Musi, is the one of UPDF amendment, amending the Act. What does it also mean? What should be the members of Parliament know before they go in? Because they could be them, those who are before the General Court Martial, but tomorrow could be anyone else. Is it? Does it also say that members of Parliament don't know that the civil courts have the powers to try civilians and they have to go to the military courts?
Of course, the members of Parliament are prioritizing politics because they are doing what their chairman is asking them to do. In return, I'm sure, for something that they may want to get from him, especially. That has been the practice. That has been the practice because the issue is they have not even the NRM caucus has not fully utilized the reasons or what the rationale for the civilian trials. They have just gone through what the president has been saying all over and over again. So I think, just like we've always noticed, that sometimes history comes back to bite some of these people.
George Musi, Partner at Pace Advocates, thank you so much. One word from you from Tobias.
Yeah, I'm so happy that we are here to get this ruling. We hope for the best, although he has told us he's not sure of it, but he had promised us that we are going to have the ruling this Tuesday. So, and today is the last day. He told us the last day is 25th. So we hope he obeys by his word, and we hope for success for our brother.
Lawyer Tobias and Lawyer Katoto Musime. It's a host of lawyers here. There are so many here waiting for the ruling for habeas corpus for the production of Aaron Kizza, a lawyer who is now detained at Chitalia. He was sentenced on the 7th of January for contempt of court by the General Court Martial led by Brigadier General Gabe Freeman. But what is happening here is that they've been told that he will give them the ruling on notice. Stephen Ibido, Fefes Swechbuga, we will now hand you back to studio because MorningAtNTV has to come to an end, and then Mwasumitia comes on at 9 a.m. Thank you so much.